Should I start?
Yes, sir. Thank you so much, sir.
Thank you so much. Thank you for inviting me and bearing me. I was a bit late, but anyway, I don't think that there is any suffering has been caused because of my delay. Thank you so much. So I don't know that this is an interesting topic. Most of the law students and other than that, any person who is belonging to the civilized society, they are initially curious about the laws, especially the criminal and civil laws, which are actually in practice in any of the country where they are visiting or where they have interest. In our country, after a long time, after the Civil Procedure Code and Criminal Procedure Code, we have found that this BNS and the criminal BNSS both have been brought, including the Evidence Act. So the purpose of bringing such laws were not only to have a society where the judgments of the Supreme Court and High Court, which is for the positive changes, they should be incorporated. Because most of the times we have seen that community service was in practice, especially in the state of Madhya Pradesh, because one High Court judge who was known as a green judge, I have seen several judgments where for the petty offences, he used to direct the petitioners and respondents that whoever is at fault, that they have to go for the plantation, they have to do some community service. And similarly, several other factors has to be considered. I have personally seen that in several matters where when you have the electronic evidence, generally the courts, they did not have the power to entertain, because this used to fall in the secondary evidence category. It was not a primary evidence. So a statement of a person as a witness was the more relevant than the electronic evidence in the form of video or in form of tape records or even some communication by email. So later, because High Courts and Supreme Courts, they started appreciating it that as the key evidence, then they had no other option than to change it. So most of the changes, especially what has caused in the BNS and BNSS, we have seen that those changes are especially from stem from the orders of the High Court and Supreme Court. What I personally feel that whenever you see that there is, other than the sections which has been replaced and rephrased, so I am not on those points, but other than that, if you start working other than the electronic evidence and community service, you will find that even this language part where the gender, the laws, they tries to make the laws gender neutral. So whenever they are mentioning the persons, and earlier it was like a male and female and some other gender signs were there. So in my opinion, even if you do not go for this gender category and you make the law gender neutral, even then you find several other laws where only ladies could have filed the complaint, and they have the only entitlement to file such complaints. So other than that, chain snatching, you find that these are the new offenses which has been earlier it was there, but especially when you see that what is the penalty, what is the conviction, and the other factors, when you consider those things, then you find that they have properly tried to deal with such issues. Mob lynching issue, like it was a prominent factor. But most of the times we see that some incitement and follow-up is that some of the following with some incident, which is unfortunate. Many mob lynching incidents has happened, and only because the nature of the mob is not under control. Earlier in the British period, suppose there is a robbery somewhere, they used to penalize the entire village surrounding that area, and they have to pay the compensation of the loot amount or the robbery amount, though the villagers were not involved. But it is a general perception that villagers had a duty to protect such government properties, being the property of the British India. So now, and in the same terms, we can't say that, but usually some laws has been brought where at least mob should be the fearful that they are doing something and they may be prosecuted in some heinous offences, and ultimately the conviction rate may be high. At the same time, you see, that's because of social change. The adultery part, earlier it was one of the ground of divorce, and other than this, you find that some prosecution was there against the male partner. But now they have completely removed, because they have found that this is the wisdom and this is the choice and will of the persons who are indulged into such activities. The ground of divorce is there, but other than the divorce ground, you will not find anything else, any other criminal action to be taken against such persons. And similarly, the unnatural sex, they have removed that part also. Sedition part they have removed, but I think that they have made it more stringent under 152. So sedition part, you can't say that this is not existent. It is there. And organized crime was never been part of the IPC, but now they have made the part in this. And other than this, the laws, especially made for the organized crime, is still existent. Like I will give you an example. Like in the state of Maharashtra, there was some few persons were arrested, a group of some persons who were part of a gambling group. So next time again, when they were arrested, the officers fixed them in the Magoka. So any person who is part of the gambling, the only provision was that you can penalize 2 times more than what you had penalized for the first time. But you can't put them behind bars for with the uncertainty and adding the Magoka in those sections, in those cases. So all these misuse are there. And ultimately, any law which is in existence, the primary purpose should be that there should be proper safeguard for not being misused of the law other than the purpose for which it has been made. So what we have seen that in several occasions, we have seen that such laws were misused. IT Act is now, it has become this more relevant, and you will find that several other like gang rape and all those offenses, crime against women has been expanded. This provisions have been added. And ultimately, if you ask me, that I will say that the entire social change and social growth traveling together with our legal and justice system, ultimately it has brought to a level where all those changes which were ultimately in the practice but not part of IPC because of the judgments delivered by the court, because of the social pressure, and ultimately now they have incorporated at one place. It doesn't mean that there will not be any further judgment, there will not be any further procedure laid down by the courts, and then thereafter they will be working on the same line. So, in my opinion, the new laws which has been brought is a good compilation. And because of such compilation and the impact of the judgments delivered by the constitutional courts, we find that there are some positive changes. The only problem with me is that the sections they should not have touched. If you are incorporating something, incorporate in the same section. The prominent sections should not be touched because everything was in practice, everything was in habit. So again, chapterization and forming them into one procedure and one part, that was, I think, not warranted. But ultimately, something has happened, and it will take some time for all the law students and many practitioners. And the same time, when we are running with the two procedures, now the cases which occurred or happened prior to the implementation of the BNS, that will go with the IPC and CRPC, and other cases which happened thereafter will be part of BNS and BNSS. And then the trial courts also, they will have to try both the matters for the similar offenses. Like in one case where the adultery is being charged, the person has to be prosecuted because it was under IPC and happened prior to this new act, but new Sanhita. And thereafter, if somebody has committed the same offense and somebody has filed the IPC section, court may reject it, terming that this is post implementation of BNS, so it can't be used, it can't be dealt with. So such issues are there, but I don't think that it will be a problem for the students. Most of the persons who are in touch with the legal hand and they understand the legality and illegality, they understand that how this situation has to be dealt. I always say that whenever you find that whether there is a law which that law is legal or illegal, where an act of somebody's is legal or illegal, or something is constitutional or unconstitutional, you have to test it from the voice of your heart. And if your heart says that whatever you have done and that is not correct, you certainly it is illegal and there will be a law against that particular act. But if you find that you have done something appropriately, then you will find that there is an exception, there is a law which is going to protect you. So this is the procedure, this is the practice, If there are any questions from any students, I will be happy to respond to those questions.
Thank you so much, sir. Anybody having any questions can ask, sir. He's kind enough to answer.
Sir, I want to ask one question
Yes.
regarding section 69 BNS and hit and run case. Do you think this is very controversial controversial sections, and do you realize that there needs some amendment in
You
section
see,
60?
hit and run cases, especially the provisions are appearing to be stringent, but you see, globally such provisions are there. But the problem in India is that again the mob culture is there. Suppose you meet with an accident, you will find that despite taking them to the patient to the hospital or the injured to the hospital, you will find several other persons are assembled there, and that assembly make you injured. So they start the behavior of the crowd, especially in the accident cases, is not appreciated. So whenever you bring a law, you have to consider the society, social format, the stratification, and then the structure of our society, that what is the behavior generally. So that is the problem. Otherwise, such provisions should be there. Suppose you meet with an accident, the error has been caused, but you have a duty, your duty to send the person to the hospital. But ultimately, if you start doing like this, and then the fear of the mob culture is always there. So on that part, I am a bit apprehensive, and I feel that there should be some exceptions. What is suggested by you should be incorporated. Yes, sir.
Thank you, sir. Any other questions if anybody would like to ask?
सर, जैसा कि आजकल कोर्ट्स में पेंडेंसी केसों की कमी आई है, पहले बहुत ज्यादा केसेस पेंडिंग थे। आजकल कोर्ट्स का प्रायोरिटी ये रहता है कि जल्द से जल्द केस को खत्म किया जाए। तो सर उसके बारे में आप कुछ कहना?
देखिए, ऐसा है कि पहले भी होता था, लेकिन अभी जैसे मीडिएशन हो गया, हम लोग ये कोशिश करते हैं कि जो मामले हैं मीडिएशन में सुलझा दिए जाए। और एक तरीका ये होता है कि दोनों पार्टियां कई बार आपस में बात नहीं करती हैं। मीडिएशन में ज्यादातर मैटर्स तो वही होते हैं, हस्बैंड वाइफ के, बाप बेटे के, बहनों के, भाइयों के। अब जैसे नए लॉज आ गए, उसमें प्रॉपर्टी बहनों के साथ शेयर करनी है, तो कई भाइयों को दिक्कत होती है। कई बार रेप के केसेस तक में जो फैमिली है उसमें जब हस्बैंड वाइफ में झगड़ा होता है, डिस्प्यूट होता है, तो वो लोग तरह तरह के एलिगेशन लगा देते हैं एक दूसरे के ऊपर। तो ये सारे मैटर अब सेटल हो रहे हैं। इसका भी एक बड़ा फायदा है कि जब आप साथ बैठते हो, बात करते हो, तो फिर आपको भी अपना फ्यूचर, अपनी लाइफ, अपनी बाकी सब चीजें, और जो टाइम आप देते हो, क्योंकि एक लिटिगेशन, एक हस्बैंड वाइफ का झगड़ा होता है तो कम से कम 16 केसेज होते हैं इस पे। और वो केसेस एक आदमी, दो आदमियों के बीच में नहीं होता है। आप उनके फादर इन लॉ को एक्यूज बनाते हो, सिस्टर इन लॉ को भी बनाते हो, वो भी आपके घर वालों को बनाते हैं। वो कहते हैं हमारे घर से ज्वेलरी चोरी करके चली गई, आप कहते हो कि हमारे साथ अननेचुरल सेक्स कर दिया, तो दुनिया भर के सेक्शंस लगा देते हैं। सो अल्टीमेटली आप जो पाते हो कि ये मीडिएशन के आने से बड़ा फर्क पड़ा है, और ऐसे जो प्रोविजंस हैं ये देश को फायदा पहुंचाएंगे। जस्टिस एनवी रमन्ना ने कोशिश की थी कि प्री लिटिगेशन मीडिएशन होना चाहिए, और आगे चल के होगा, ये देर सवेरे होगा कि प्री लिटिगेशन मीडिएशन करिए, पहले बात करिए, अगर आपकी बात नहीं बनती है तभी कोर्ट के अंदर आइए। तो ये चीजें धीरे धीरे शुरू हो रही हैं। मैं कई ऐसे केसेस देख रहा हूं जहां पर हाई कोर्ट कंटेम्प्ट में चला गया, लेकिन अब सुप्रीम कोर्ट ने उसको मीडिएशन में भेजा। आपको कंटेम्प्ट में जाने की जरूरत नहीं है, आपने कोई ऑर्डर पास किया, आप अगर लगता है, कोई पॉसिबिलिटी दिखती है कि जहां पर सेटलमेंट हो सकता है, तो आप जरूर कराइए उसको। और वो अगर नहीं होता है तो फिर आगे जाना चाहिए। तो लिटिगेशन में कमी का एक कारण ये भी है। और दूसरा जो आप कहते हो कि लोक अदालत है, जैसे वो भी हम करते हैं। लोक अदालत में आप ये पाते हो कि एक दिन के अंदर ही करीब 1 लाख, 2 लाख, 3 लाख मामले सुलझ जाते हैं। तो इतना बड़ा नंबर जो कि पेंडिंग रहता, पेंडेंसी लिस्ट में था, वो खत्म हो गया। सुप्रीम कोर्ट में भी लोक अदालत लगाया गया, प्राइवेट जो बाकी डिस्ट्रिक्ट कोर्ट से उनको डायरेक्ट किया गया। कई बार जहां से अपील आई है उन्हीं को वापस भेजा गया कि आप लोक अदालत में ठीक करिए इस मामले को, अगर आप नहीं कर पाए तब ये केस हमारे पास आएगा। तो मेजोरिटी ऑफ द केसेस में सेटलमेंट हो जाता है, ये भी एक कारण है। और धीरे धीरे जो स्वभाव है, आम तौर पे एक आम भारतीय का स्वभाव था, कोई पढ़ लिख लेता है ना तो धमकी देता है, हम कोर्ट में देख लेंगे आपको। ये कोर्ट में देख लेने वाली जो बात है ना, ये बड़ी खतरनाक है, इससे बचना चाहिए। आपको कोर्ट में देखने के बजाय पहले आपस में देख लीजिए, नहीं बनती है फिर कोर्ट में जरूर देखिए, लेकिन पहले ही कोर्ट में देखना ठीक नहीं है। तो वो एक मेंटेलिटी में भी चेंज आ रहा है लोगों के। जैसे बहुत से कारपोरेट मैटर्स हैं, उनके डिस्प्यूट यूं सेटल हो जाते हैं, आप उनको बिठाइए, बात करिए, शायद मेजोरिटी ऑफ द केसेस में 99% केसेस में सेटलमेंट हो जाता है। लेकिन जब भी आप देखते हैं कि कोई फैमिली का झगड़ा है, भाई बहन का झगड़ा है, दोस्तों का झगड़ा है, वो सेटल होना जरा मुश्किल हो जाता है। तो इसलिए लिटिगेशन भी धीरे धीरे नए रूप में आएगा समाज के साथ साथ। और हम लोग सब भी हो रहे हैं ना, सिविलाइज सोसाइटी में आ रहे हैं। दो हम लोग कहते हैं कि साहब सोसाइटी तो वो अच्छी थी जो पहले थी, ये वाली उतनी अच्छी नहीं है जो आज की सोसाइटी है। पहले बाप बेटे में एक रिश्ता था, बाप के कहने पे बेटा जंगल चला गया, ये चला गया। हम रामायण की, महाभारत की बाकी घटनाओं के बारे में जिक्र करते हैं। लेकिन मैं ये भी पाता हूँ कि जो मीडिएशन है वो काफी, उसका ब्राइट फ्यूचर है। और अल्टीमेटली जो लैंग्वेज है कोर्ट्स की वो इंग्लिश हो चुकी है, और जो कल्चर है कोर्ट की प्रोसीजर का वो भी इंग्लिश हो चुका है। तो धीरे धीरे जो चीजें हैं वो अगर आप फॉलो करने लगे तो लिटिगेशन में आप कम जाएंगे, और लिटिगेशन से बचने की कोशिश करेंगे। आउट ऑफ कोर्ट सेटलमेंट्स होना शुरू हो जाएगा। तो आपकी बात ठीक है, लिटिगेशन कम होना चाहिए। कम हो तो नहीं रहा है, आपने पता नहीं कहाँ से फिगर निकाला कि कम हो रहा है, लेकिन कम हो नहीं रहा है। हमारे यहाँ तो सुप्रीम कोर्ट के बाहर एक घड़ी लगी हुई है जहां आप देख सकते हैं कि लिटिगेशन कितना हो गया, कितना छूट गया, कितनी पेंडेंसी है। बिल्कुल बाहर चौराहे पे ही लगी हुई है, तिलक मार्ग और भगवान दास की क्रॉसिंग पे। तो आप उससे देख सकते हैं। तो कम तो नहीं हो रहा है, लेकिन यह है कि आप फाइलिंग से बचने की कोशिश हम लोग कर रहे हैं, और ये कोशिश कर रहे हैं कि मीडिएशन से हल निकल जाए। जी।